Good afternoon and welcome to The Law. This is your Legal Light. It is your health law. I'm your host, Samson Ladi Anyanini. And this afternoon, we will ask the question, 4 answers. How do you deal with the property of the dead so you don't get into trouble? Perhaps so you don't get into jail. There are many stories of how widows especially are rejected, thrown out of the property, together with children, and extended family members take complete control without lawful authority. How should the property of the dead be dealt with? What is this thing called intermeddling? And what has the Supreme Court said about this very recently? We'll be right back. Got a guest, a teacher of the law who has written recently about the subject matter.
The Law 101, High Court Civil Procedures Rules 2004, CI 47, Order 66, Rule 3, Intermeddling with Property. Where any person other than the person named as executor in a will or appointed by court to administer the estate of a deceased person takes possession of and administers or otherwise deals with the property of a deceased person, the person shall be subject to the same obligations and liabilities as an executor or administrator, and shall in addition be guilty of the offense of intermeddling and liable on summary conviction to a fine not exceeding 500 penalty units or twice the value of the estate intermeddled with, or to imprisonment for a term not exceeding 2 years, or to both.
And my guest this morning is Albert Gyamfi. Albert Gyamfi is a lawyer with Total Legal Services, popularly known to be in Kumasi, but they are beyond Kumasi. He's also a lecturer at the Wisconsin International University College, Kumasi campus. Albert, thank you so very much for agreeing to join us this afternoon to help us educate our people. Albert, please unmute your microphone. Great, I can hear you now.
Yes, thank you for having me, Samson, and my greetings to your cherished viewers.
Great. So we just read a portion of the law to our viewers, and this is how we start the show every time, what we call the Law 101. You have written recently about this particular provision of the law on the back of a decision of the Supreme Court. What is this law from CI 47, and what has happened to it in the Supreme Court?
All right, thank you, Samson. So, Order 66 Rule 3 of CI 47, prior to the decision of the Supreme Court, established what was called the offense of intermeddling. Now, whenever a person dies, whether testate or intestate, we say that his properties devolve onto his personal representatives. So if the person dies testate, his property devolves onto his executors. And if he dies intestate, his property will devolve onto his personal representatives or his administrators. Now, by law, apart from the executors and the personal representatives of the deceased, until the estate is distributed, no other person has the right to use, possess, or deal in the estate of the deceased person until the appointed personal representatives actually do the execution by way of vesting asset. And anyone who does that is guilty of the offense of intermeddling. And that was what was provided for under Order 66 Rule 3 of CI 47. Now, similar provision is also contained under Section Section 17 of the PNDCL 111, which is the interstate succession law. And but the Supreme Court has struck out Order 6603 in the case of ex parte Yvonne Amponsan, but we still have Section 17 of PNDCL 111 still intact in our law books.
Right. I'm going to get back to you to explain a few things. But before we do so, I'm going to read the Section 17 of PNDC Law 111, 1985 that you refer to. But we will need you to explain. You have used certain words. You refer to if a person dies testate or intestate. What does it mean in law to say somebody died testate and somebody died intestate? You also referred or spoke about executors. Executors. We want to be educated. Who do you mean when you say executors? And I think beyond that, you spoke about personal representatives. So you break that down for us. But you say that even though the Supreme Court in the recent case has struck down this provision of Order 66.3 in CI 47, it still exists in PNDC Law 111 in Section 17. Section 17 reads, offenses against spouse and entitled person. A person who, before the distribution of the estate of a deceased person, whether testate or intestate, unlawfully ejects a surviving spouse or child from the matrimonial home, contrary to Section 16A, unlawfully deprives the entitled person of the use of 1. A part of the property of the entitled person. 2. A property shared by the entitled person with the deceased to which this act applies. Or 3. Removes, destroys, or otherwise unlawfully interferes with the property of the deceased person, commits an offense, and is liable on summary conviction to a minimum fine of 2.5 penalty units and not exceeding 250 penalty units, or to a term of imprisonment not exceeding 1 year. And the court or tribunal shall make any other orders that it considers necessary for the reinstatement of or reimbursement to the person thus ejected or deprived. That's a lot. But Albert,
Yes.
now explain to us. You say if a person dies testate or intestate, executors, personal representatives, who are they?
All right, so death is an inevitable life occurrence. Of course, one day we are all going to die. But in law, there are two ways a person can die. You either die testate or you die intestate. So if a person is said to have died testate, we say the person died leaving behind a will. So you can either distribute your properties in a way and manner you want, if by making a will, or you can die intestate, that is without making a will, and your properties are distributed in accordance with PNDC Law 111. Now, if a person makes a will, he appoints persons who are to administer his properties after his death and to distribute it in accordance with his will. Those persons appointed are referred to as the executors. Now, obviously, if you die intestate, you will not have the opportunity to appoint persons who would administer your properties after your death. So the court would appoint or foist on you, let me put it that way, the deceased person, persons who should distribute your properties after your death. And those persons are referred to as administrators. So unlike executors, which are appointed by the testator, usually trusted persons, trusted friends, administrators are appointed by the court, and the view of the executor does not, or the deceased person, sorry, does not really matter.
Right.
In terms of that, yes.
You just use another word, testator. That's the dead person.
All right. So the testator, yes, it's a person who makes a will. Okay,
Right.
so if you make a will prior to your death, then you become a testator. I mean, if you don't make any will, then probably we can classify you as a deceased person. Let me put
Right.
it that way.
And you've been using the word estate. What are you talking about? Real estate or what?
All right, so the properties that a deceased person leaves behind, self-acquired properties of a deceased person, which he leaves behind in law are referred to as his estate. So the total assets, movable and immovable properties that a deceased person is survived by or he leaves behind is what is referred to in law as his estate. Pardon me, sometimes it becomes difficult to explain some of these words.
No, you are perfect, and we enjoy the way you are doing it because you can't interchange these legal terminologies. You say them, and then I ask you to explain to our audiences, and you are doing a very fantastic job for us. Now, as you just heard Albert say, that if you die testate, it means you made a will and you have decided how your property should be distributed. He says your property, movable, immovable, whatever they are, that you leave behind according to law, or is referred to as your estate. And if you make a will, you will appoint someone. He refers to trusted friends and so on. The person you appoint, that on your death, he should lead the process to distribute your property to the people you want to benefit, is called the executor. But if you die intestate, his explanation is that intestate means you died without making a will. And if that happens, then there's a law in Ghana that will now do what he calls foist on you. You know, how the property, your property should be distributed. And that one too, there will be the need for administrators, not executors, because you didn't pick, people to do that. Thank you so very much for this education, Albert. Now, if you are just joining us, this is the law. It is your legal light. It is your where we make sure that you get all the help that you can get. Now, Albert Jemfi is with Total Legal Service, and he's a lecturer, Wisconsin International University College, the Kumasi campus. He's also an author. In the course of this show, we'll let you know what I mean by saying that he's an author. He's an author of a legal text. Now, Albert, so you said that the Supreme Court has struck out this law or has cancelled this law in the CI 47, which was used to punish people for dealing with the property of the deceased when they didn't have power to do so. But you said the law still exists in another form, in the PNDC law 111 section 17. Please explain that one to us.
All right, first let me say that per the Supreme Court's judgment in Ex parte Ivanam Ponsa, they say that the law still exists under section 17 of PNDC law 111. And that will be the starting point of my discussion. Now, if you look at PNDC law 111, section 17, as you rightly read, it criminalizes any act of any person that seeks to remove, destroy, or otherwise interfere with the property of the deceased person. Now, these words are very broad terminologies that can be interpreted broadly, particularly the generic term otherwise unlawfully interferes. Now, if you are not an executor, you are not an administrator, you are not a beneficiary, you have no right to interfere with the property of the deceased. Now, if you're a beneficiary, you have no right to interfere with the property of the deceased before distribution. So clearly, if you should look at or interpret the word otherwise unlawfully interferes, it would include using, dealing, administering the property of the deceased. So invariably, even though that has been struck out under Order 66 Rule 3, the word still, the phrase otherwise unlawfully interfere still covers the acts which were prohibited under Order 66 Rule 3, if you are to interpret it as I've just explained.
So it does mean that still, even though the Supreme Court has given this decision and in one law, broadly speaking, has cancelled the punishment that existed for people who did the wrong thing, in another law, you can still be punished. And remember, in Order 66, Rule 3 of the Civil Procedure, we read the law where it says, intermeddling with property, where any person, other than the person named as executor in a will or appointed by court to administer the estate of a deceased person, takes possession of and administers or otherwise deals with the property of a deceased person, the person shall be subject to the same obligations and liabilities as an executor or administrator, and shall in addition be guilty of the offense of intermeddling and liable on summary conviction to a fine not exceeding 500 penalty unit or twice the value of the estate intermeddled with, or to imprisonment for a term not exceeding 2 years or both. Now, who is an administrator? Who qualifies to call themselves an administrator?
All right, something before I come on to that, let me say that there's a slight difference between Section 17 of PNDCL 111 and the Order 66 with 3 of CI 47. Now, Section 17 of PNDCL 111 regulates offenses before distribution. Now, if you look at the opening sentence, it says that any person who before the distribution of the estate, in other words, the offenses indicated, interpreted literally, cannot be committed after distribution. So when vesting assent, or let me interpret vesting assent to mean the legal document by the administrator or the executor to the intended beneficiary is issued, we say that distribution has been completed. It appears that Section 17 cannot be committed after distribution, but Order 66(3) permitted a person to be cited for intermeddling even after distribution, as there's no timelines on that. Okay. Now, again, Section 17 could also punish an executor. Now, Section 17 says any person, which would include an executor or administrator. Now, Order 66(3) said any person other than an executor or administrator. So it also excluded executors and administrators under Order 66(3). But these people can also be punished under Section 17. So while I'm still maintaining that the provision is saved under Section 17, there's still some differences between the two provisions. Now, you also ask who qualifies as an administrator. Now, if you die without making a will, which lawyers always advise, it's not their proper thing to do, but people still want to do it regardless. If you die without making a will, after your death, some persons are entitled by law to apply for what is called authority to administer your estate or to be appointed as administrators. Now, these people are ranked in order of priority, and the court is at liberty to choose any of them, not more than 4, to administer your estate. Now, the first people or group of people who can apply will be your children. So your children are entitled to apply to be appointed as administrators of your estate. Second group is your spouse or your spouses. I mean, in Ghana, where polygamous marriage are encouraged, someone may have more than one spouse. So your spouses are also entitled to it. Then we also have your parents who could also apply to be appointed as administrator of your estate. And the last group of people is your customary successor. So these 4 people can apply to be appointed as administrators. Like I said, it's a discretion given to the court to appoint any of these class of people to be administrators, and the court can choose up to 4 of any of these people to be administrators.
If you have a relative who is dead, who passes on, you are not allowed to deal with their property unless you have applied to the court and the court has appointed you as an administrator. And by that power, which we call LA or letters of administration, then you can begin to take control of the property. And you say the people that the court can give the power to manage the property of the person who is dead are: one, in order of priority, the surviving spouse, it could be the man, it could be the woman, the surviving children, any surviving parent, or the customary successor of the deceased person. So, how should they do it? Is it all these four people? If there is a wife or is a widower, then children, then if there are surviving parents, they also join. And then if there is customary successor, they also join. Four. Then you all go and ask the court to give you the letters for administration. Or how is it done?
In practice, there's nothing wrong with all four people agreeing that they will all apply for letters of administration. Like I mentioned, the discretion lies with the court. The fact that you're a customary successor and you are part of the group of people that can apply for letters of administration does not necessarily mean that the court must appoint you as an administrator. If in the view of the court, your presence would not augur well for the administration of the estate, the court can exclude you. Again, there could be situations where a man, or let me say a woman, may have a number of children from different spouses. Now, the practice has always been that when it comes to children, one from each mother may apply for letters of administration so that they can also cater for his interests as well as the interests of his siblings. So let's say a man has 4 children, 2 from 2 different women, then one of each may come together and apply for letters of administration. Now, the full focus is for the court to appoint people who would cater for the interests of the beneficiaries. And if you look at the PNDCL 111, the beneficiaries for the properties of a person who dies intestate are the children, the spouse, the family, and the parents. So once a court will appoint people who, in the view of the court, would ensure that the interests of these 4 people are catered for, then the court can do so. The court does not necessarily have to appoint one from each group. The court appoints as it appears to the court right to do so.
Great. So you're still here with us on the law. This is your legal light. It is your health law. And we are dealing with the topic intermeddling with the property of the dead. How do you deal with the property of the dead? And our guest is Albert Gyamfi. He's a lawyer with Total Legal Service, and he's a lecturer, Wisconsin International University College, the Kumasi campus. So if you are enjoying the show so far, we will open the phone lines in a bit for you to join with any questions that you want to ask of our guests for any education. But remember that some things must not be done. If someone passes on, you don't by yourself assert yourself and begin to run their property as if the law allows it. The proper way to do it is, if they didn't leave a will, if they left a will, the will will be used to tell who benefits from what. If they didn't leave a will, then it's PNDC law 111 that will be applied, the interstate succession law, and it is very clear what should be done. You go for letters for administration, as she just educated us, so you become administrators or an administrator of the property, or the property called the estate. And then on the basis of that, whatever you get, you may get subsequently what he calls the vesting assent. Then you become, as it were, the owner of what has been left behind. If you don't follow the law and you intermeddle, you start to deal with the property when you don't have the power to deal with the property, you are intermeddling, and then you could find yourself in trouble. And that is where the law prescribes punishment for you. what is the punishment? The punishment is that you could get 1 year in jail. You could go to jail for a year. You could also be asked to pay a fine. And from what the law says, you could be asked to pay about 3,000 Ghana cedis. That's 250 penalty units, if my calculation is right. A penalty unit is 12 Ghana cedis. Right. So now the administrators or the administrator, normally we hear the stories where it applies to especially widows, that somebody is dealing with them wrongly. What will somebody do that will amount to committing this offense against a surviving spouse and the children, for example?
Right. So the law protects surviving spouse and children. Now, if you look at PNDCL law 111, surviving spouse and children are entitled to, if my calculation is right, 12/16 of the estate of the deceased person. So mathematically, that would be about 80% of the properties of the deceased. And as such, they are in the special place of the law when it comes to where a person dies intestate. Now, if a person dies intestate, we say that the matrimonial home is for the surviving spouse and the children. So if they are in there, you have no right to eject them. And under Section 17, the law is clear that if you eject the surviving spouse and children from the matrimonial home, you commit an offense. That is clear. Ejecting them from the matrimonial home, wanting to live with them in the matrimonial home, trying to gather properties of the deceased. Mostly in our Akan culture, they say that after 1 year, if you have to wait for 1 year before the properties of the estate of the deceased are open, so they start packing where is his jewelry, where is his car key, all that for safekeeping for a period of 1 year. All that will amount to intermeddling. The matrimonial home and every asset in the matrimonial home, including the cars of the deceased person, his movable property, fridge, TV, whatever, are for the surviving spouse and the surviving children. So if you touch any of these properties, you are most likely to be charged with intermeddling.
So let's see. If, as you say, if there is a will, then there is an executor, someone that the deceased or the dead person has appointed to be the one to lead the process to get what you had mentioned as a probate, so that the property or estate can be distributed. In the same way, if it is someone who died intestate, then they will have to go and get LA, or the letters for administration, which subsequently can be used to distribute the property. But before you get the LA or the letters for administration, to get that power from the courts, who can deal with the property of the deceased?
That has been a very difficult question under a Ghanaian system, particularly for our culture. Now, by law, if a person dies leaving behind a will, then automatically the property will vest in the executors. The problem, however, is that the will of a person in Ghana is usually not read until after the burial. So we get to know who is an executor after the burial. Now, if you look at the Administration of Estates Act, the Administration of Estates Act clearly states that in the absence of an executor, the estate of a deceased person will vest in the customary successor if the entire estate devolves under customary or will devolve onto the Chief Justice. Now, obviously, in Ghana, per PNDCL law 111, hardly will the entire estate of a person devolve under customary law. Like I already mentioned, 80% of it goes to the surviving spouse and children. So, looking at it technically, until the LA is applied for or the will is read and we know who the executors are, then the estate of a deceased person under Ghanaian law is most likely to devolve onto the Chief Justice. So for safety reasons, until LA is applied for or until the will is read for us to know who the executors are, it will be safe for you to desist from intermeddling with the estate of a deceased person, because if you're not the administrators or the executors and you interfere, you are likely to be punished for intermeddling.
Thank you very much, Albert Jemfi. Albert Jemfi is with Total Legal Service, and he is a lecturer at the Wisconsin University, International University College, Kumasi campus, and he's helping us understand how to deal with the property of someone who has died without a will, more particularly died intestate, in a way that we don't get into trouble and perhaps get to go to jail for 1 year, or we are made to pay fines by a court. So please take note of that. We are opening the phone lines in the next 4 minutes so that you can join us with your questions. This is the law. It is your legal light. It is your health law. And we're dealing with the question of intermeddling. What exactly is it? We will go to this particular question, which since we introduced that we're going to have this discussion, a number of you have sought to ask. And your concern is that if you are a relative of the person who is dead, why should anybody say that you are intermeddling, you are doing anything wrong with the property, and therefore you can be put into jail? So, Albert, in the period before the LA or the letters of administration is taken, supposing the property is one that is, say, is a landed property or is a vehicle that is used for commercial purposes, and the person has, supervised the process, taking rent, collected what they call the sales from those who are using the vehicle, what will happen?
I don't think if you're in such a position and you try to gather the assets of a deceased person, not for purposes of interfering with it, but for safekeeping, so that it could be distributed when administrators are appointed, you do not commit the offense of intermeddling. Now, if you look at Section 17, the law principally says unlawfully deprive the entitled persons of the use. So the law has a mens rea of you unlawfully depriving persons of the use. So if I am only gathering them for safekeeping, I am not depriving people of the use. But let me sound this warning. The general practice has been that when a person dies, people would want to go into his bank account for money for the organization of the funeral. That is intermeddling. That is intermeddling. Wherever the family will find a loan to organize a funeral, they should do so. And when LA has been granted or probate has been granted, then if there's any property to liquidate that debt, they use his property to do so. But you cannot go into his bank account, withdraw money for purpose of a funeral. As soon as a person dies, doctors declare him dead. His bank account is closed until LA or probate has been granted. So in the question that we asked, if the person has vehicles and the drivers are supposed to do like what Jews or West sales, you can receive them, keep them for safekeeping, and when the administrators are appointed, you account. If you are unable to account and some monies have gone some way, then you can be said to have been depriving the beneficiaries of the use and the guilty of intermeddling. So gathering properties in good faith for purposes of administration, in my view, does not amount to intermeddling.
Okay. So if I'm collecting rent and I'm taking sales from a shop or whatever it is, you say I should be doing so for safekeeping. At the right time where the administrators have been appointed and you say I have to account, will I be required to show that I have invested the money and there is interest on it or something? Or I should just collect the money, put it somewhere, Once you ask for it, I bring it to you. This is what it is.
Executors, even executors, are not bound to invest the property of the deceased. Now, note that if you try to invest and the investment backfires, you are likely to be charged for intermeddling. So then you play the proverbial servant who dug the ground and put the money there, so that when it's time for accounting, you just produce what you have collected. But if you try an investment, probably you invest in maize gold or any of these schemes that backfire, you're much more likely to be charged for intermeddling. So I would advise that you keep it for safekeeping. And when it's time, you produce just what you have obtained.
At the time you are doing what you call gathering, you are making sure whatever property he has, if there is money coming from it, you are collecting everything and keeping safely and protecting the property. Those who depend on the deceased person, are you allowed to give them money to do things they need? Can you use some of that money for funeral and other things that are required? Okay, I think Albert's line is frozen. We will surely get back to him. His line has been very clean so far. And Albert Genfi is a lawyer with Total Legal Service and lecturer at Wisconsin International University College. Thank you. You're back. So if you heard my question, how do you answer that?
Oh, can I come again? I think the line.
Yeah, so if I'm doing what you call gathering, before their letters of administration are taken, the family needs money, the people who depend on the person who is dead, they need money to survive. School fees have to be paid, water bills and things have to be taken care of. And I've taken rent, I've gone to his shop, I've taken sales and the rest of them, and you say I'm supposed to take it for safekeeping. Am I allowed to use part of that to take care of these expenses? Am I allowed to use part of that to pay for funeral expense?
I mean, that is a difficult one. I would say if the deceased had certain commitments that he was supposed to undertake while alive. We gave an example of he having to pay school fees. Let's say he and his family were living in a rented apartment. Rent is due, and we have not yet had his funeral, so we have not applied for letters of administration, but rent is due. The surviving spouse and children will need a place to live. Can I pay for the rent?
Yeah, so at the right time, you'll be called upon to account for it. So you account.
I think that, in my opinion, would not amount to intermeddling.
All right.
The crucial thing has to do with what you exercised in good faith. There's a reported case of one woman who claimed, as an administrator, claimed that one of the surviving children of the deceased had malaria, suffered from malaria. So she had to sell the only house of the deceased to as it is, take care of the medical expenses for malaria. I mean, that is something that you do which is not in good faith. I mean, malaria is not cured by selling an entire house. So I feel the question has to do with prudency. Were you prudent enough in the use of the resources of the deceased? So the law would not say that we should allow the estate to go to waste because administrators have not been appointed.
All right.
I mean, in the time frame, certain expenses will have to be paid. We will not allow the children of the deceased to come home until we get letters of administration before their fees will be paid. I think those things done in good faith will not amount to intermeddling.
Okay, thank you very much. So all of you who didn't know and have suffered because either your father, your mother is dead and their property, somebody who claims to be a busuapenyin or the elder brother or elder sister or some extended family people are taking over and trying to do all sorts of things. The law protects you. Take advantage of it. And that's why we are here at the law. It's your health law. It's your legal light. Let's go to Augustine Ado. Augustine, you're calling us from Nkoko. Let's hear your question for Albert.
Thank you very much. My question is, if somebody is dead and without a will, that means the intestate succession law has to be applied. That's PNDCL law 111. Now, as a financial institution, if somebody is dead and the family has come to find out how much the person having in his or her bank account, and you see that the money left in the account, let's say it's less than 1,000 Ghana cedis. So your investigation, you get to know that the person doesn't have any account anywhere, don't have any money anywhere. And so that is the only money left in the person's account. Now, going to do the letters of administration may cost them more than 1,000 Ghana cedis. And then those people consider the money which is left in the bank account. Going to do LA for more than 1,000 to come for, let's say, 200 or 300 Ghana cedis in their account. It seems that economically, it is not, to me, it is not advisable. So is there any other way that the family can do to claim the money from the bank without doing the letters of administration, which is very expensive to do?
Well,
thank you.
Well, thank you very much. Next caller coming. But before that, Abed Jemfi, what do you say to this? I don't know, without the letters of administration, even if the bank is going to entertain you by giving you access to the money?
One thing the bank should know is that deposit which a deceased person has with the bank is a debt owed to the deceased person's estate. Now, the only person who has the right to recover debt owed to an estate are the personal representatives, which in this case are the administrators and the executors. So if the bank, like my brother just described, appears to be a very merciful bank, and they decide to give money out before letters of administration is obtained, the bank is doing so at their own risk, because when letters of administration is obtained or probate is obtained after the monies have been released, the personal representative can still sue them for the money, since they paid it to the wrong person. So the bank should be wary of that. And I don't think applying for letters of administration is that you are supposed to pay for the estate duty, but the estate duty is charged per the value of the estate. So if the person has 1,000 Ghana cedis, he only pays a percentage of that 1,000 Ghana cedis as estate duty. So I don't think it is too expensive to obtain letters of administration if the estate is.
Let's go to Vincent. Is calling from Hohoi. Vincent, let's hear your question.
Yeah, my question is: there are instances where parents or owners of certain properties give some of these properties, for instance, a room or a house, to their parents or someone in their lifetime before they die. And when these people die intestate, can there be that right for the one who has received that in his or her lifetime to claim it to himself that my dad or whoever gave the property to him gave it to me in his lifetime before he died, so it is no more part of those that are shared?
All right. Abed, what do you say?
Yeah, so when it comes to estate, we are looking at the properties the person had prior to his death. So if the deceased are gifted something before his death, those properties no longer form part of his estate. And persons to whom they were gifted acquire absolute right in those properties. So if he has a house and he gave a room to his mother while he was alive, then that particular room does not form part of his estate and will not be reckoned when you are looking at the properties of the deceased person. So whoever has it acquires an absolute right to it and will never be deprived of it, even if LA or probate is obtained.
If he gave it as a gift to any of his children, his wife, or anybody whatsoever, that does not form part of his property, so it doesn't become a subject for the estate.
Let me sound this question. But if it is to his children, and in his will, he gives that particular property to someone else, then that gift he made is revoked. So when it comes to gifts made to children of a deceased person, they can be revoked at any time, either during his lifetime or by his will. So if your father gives you something in his lifetime and he makes a will, give that same property to another person, the gift made to you is revoked. But this applies only to
That's
children,
right.
no other.
Let's go to Jude. Jude, you are calling us from Takrady. Albert is waiting for your question.
Yeah, there's this issue that the will has been done. The lady is dead, but it does not be executed. But the beneficiaries are enjoying it. Is it a intermeddling?
Yes, lawyer.
I didn't get the question right.
He says
the will has not been executed.
Exactly. The will has not been probated or whatever, but the beneficiaries are already,
yes, that is also intermeddling. Once there's a will, the will has to be admitted to probate. Then the executor will take charge. Even if the will has not yet been admitted to probate, the estate vests in the executors of the will. So beneficiaries have no right to property of a deceased person prior to distribution. And if beneficiaries interfere with the properties of a deceased person prior to distribution, that will amount to intermeddling.
Right. You had earlier been using the expression matrimonial home. Matrimonial home. You can't touch it. What is that one?
All right. So by law, matrimonial home is where the deceased and his spouse and children lived prior to his death. But where the deceased has more than one house, the law gives the surviving spouse and children the right to select any of those houses as the matrimonial home. So for matrimonial home, if it is only one house, that is the matrimonial home. If there are more than one house, the surviving children and spouse have the liberty to choose any of them as the matrimonial home.
All right. Adam, you're calling us from Dansuman. Let's hear you.
Yeah, good afternoon, Council.
Yes, go ahead.
Please, I would like to ask, is it right if you have a property that you have paid a will? Is it right that when you are like alive, you should call a case and inform them about it?
Okay.
Or it is not right? Like, I just want to know about it.
All right. Thanks, Adam, for calling. Yes, Albert. Once you are alive.
I think we say in law that wills are ambulatory. A will takes effect after your death. So before you die, you can change your will at any time. Now, usually where a person discloses his will when he's alive, but changes it subsequently during his lifetime, there's always that challenge on grounds that the will is not valid because someone saw the will and now the different will is presented to the court. So it's not a good practice to disclose your will prior to your death, no matter how the pressure is, especially when it's coming from. We all know the source where it's coming from. You are not supposed to disclose the contents of your will. Let the court read out your will for the first time for people to know whether they are beneficiaries or not. I know a situation where a nephew spent a colossal sum of money on his uncle's funeral, knowing very well that his uncle had made a will and left so much property to him. But upon reading the will, that will had been revoked and a new one had been made and he was left with nothing. So if you don't want to create that acrimony in your family, you shouldn't disclose your will while you're
okay. Or when you have done a codicil or you have changed it a bit, you still call the people and let them know so that there's no trouble.
I mean,
like this guy, what he suffered. All right. Mamia in Michelle Camp. She is on the line. Hello, Mamia.
Good afternoon.
Good afternoon. Go ahead.
Can I speak my own local language?
Which language?
Chi.
Chi.
Yeah.
Okay, go ahead.
Okay. Me pacho, we are in it right now. Now, when my father died, after 1 year, he had kept part of the property already. That is his clothes and blah, blah, blah. We had kept another left with the house and a portion of the land. But there may person me say, bear money free moi. Oba no a otia se no ye wife no. Only right to say okoni kunu dem ana. And ye one. Nyesi ama mi bisa no. Stepchildren ewom. Inti after death no. Stepchildren in the crap me papa a room key up to today. Omuko efie ho ye be fire papa enyama ye be prapa ye papa dem ye be fire papa nyama for 1 year. Inti almost sa papa ne bia e won a bedroom e call village without wife no.
Okay.
Inti so wife ne fie ho no te. The wife is living in that house. Esi no na ye pese ye hu say e right up to now. Children in the papa no.
I thought I heard you say as me to say now woka say ye ma okunafo no kwan e ma ne nko efie ho mom.
Efi say safo ne won kola ne ho.
Be o say ho no wote. E
ho no te efie ho no te. But
how can she live there when she has no access to the place?
Because only bedroom ni safo.
Nti bedroom na yatum.
Okay. The bedroom
no. All right, thank you. Thank you very much. Thank you very much, Mamia. Yes, lawyer.
Yes, this happens most of the time. Like I explained earlier, the mother, I don't know whether I should speak the local dialect, at least for her to know. Number we see, name mom say, "Sia," I don't see intermeddling maybe. But intermeddling because a crime also because police station, no come make a complaint. They say I will say Obia ko police station and come make a complaint bia. One timin chair Obia will wedge up a day. One timin say me fire fan tuma I can't fee. All that thing amounts to intermeddling. But once again, someone has to make a complaint to the police before an action can be taken. It used to be quasi-criminal. You could file an application, but that is what the Supreme Court has struck out. So now all intermeddling has to be reported to the police for investigation and possible prosecution.
Right. Mamea, I hope you have heard and you will take a cue accordingly. Right. So if you are joining us, you have missed, but always know that on Mondays, this show, there's a repeat broadcast of this show on Monday from 11 to 12 noon on this same channel. So you can watch it again, Intermeddling with Property of the Dead. And our guest is Albert Jemfi, who is with Total Legal Service and a lecturer at the Wisconsin University, International University College, Kumasi campus. And I said he's an author. Look on your screen and you see shortly what I mean when I say he's also an author. He's the author of this book, Principles of Commercial Law in Ghana. You've heard us, we've treated sale of goods. He's treated the subject there, sale of goods, hire purchase, conditional sale, law of agency, and he has got illustrations and practice questions for those of you who need it, right? So you can zoom into it, take a picture, and then you know if you want one of it, you know where to get it. Hopefully, we may be lucky. Next week, God willing, we may have Albert Jemfi back together with a judge who has also written about this particular subject after the Supreme Court gave that decision that we refer to. He's a judge who has been on this show before, and you really enjoyed him as well. So we may have him also here. I'm talking about Justice Alexander Osei Tutu. He may join Albert to bring us a second installment. We are hoping that you will enjoy it. Albert, before you go, in the next 30 seconds, what will you say as advice?
One thing I would want to say is that someone toiled hard to acquire property. Now, fortunately for you, the person is dead and you are supposed to be beneficiaries. Even though by law, you are going to be a beneficiary during the distribution, you are supposed to wait for LA to be granted or probate to be granted before you can enjoy your benefits under the estate of the deceased person. Now, interfering with the property of the deceased prior to distribution amounts to intermeddling, and I would seriously discourage it. Otherwise, you might end up in prison for the offense of intermeddling. That is what I would want to say.
Okay. So next week, part of what we will discuss will be the question as to we have a tradition, we have a religion that determines how, when somebody dies, we should deal with their property. Why are you saying I should go for an LA or something before? This is our tradition. The tradition says, if my brother is not there, I am the one who inherits him. I'll go and take his property, and you are complaining. What are you talking about? Right. So we'll deal with all of this next week. Thank you once again very much, Albert Jemfi. This has been The Law. It's your legal light. It is your health law. I'm your host, Samson Ladi Anyanini.